Ito po si Patrick Vlog. Good morning everyone. Today is Wednesday. And pag-uusapan po natin ngayon ang umiinit na issue tungkol sa PhilHealth at ang pag-insert ng ibang insertion and ang insertion sa BICAM versus GAA. Pag-usapan natin ito mga guys. May pag-asa na ang taong Pilipino to. Good morning everyone. Sana nasa mabuti kayong kalagayan, especially ang nasa Pilipinas. Alam niyo po kami na mga OFW minsan ay hindi na nakakatulog sa pangyayari sa ating bansa dahil maraming mga anomalya ang ginagawa ang ating administrasyon ngayon at marami pa rin ang nagtatanga-tangahan. Marami pa ring tanga at naniniwala sa Marcos administration na siya ay magaling. Iwan ko bakit ganyan sila katanga ngayon sa mga nangyayari sa ating bansa. Nasa korte na nga ang reklamo. Lifting up kay Marcos na si Marcos daw ay magaling na presidente. Marami daw nagawa. Opo, magaling siya, magaling magnakaw, maraming nagawa, maraming nagawa na na pag-insert nila ng sa BICAM to GAA, tapos yung Maharlika Fund, wala ng pera, ang pagkuha ng pera sa PhilHealth, yun, ang mga kanilang nagawa. More than one is marami na yan, pero more than 3 pa yan. Nako, pag-uusapan natin ito, ano kaya ang resulta dito? Pag-usapan natin na pakinggan ang sinasabi nitong Supreme Court, BICAMERAL insertion versus GAA. May laban ba ang administrasyon o may laban ba ang community at ang institusyon? Okay, let's start. I hope that you won't forget to subscribe. Please subscribe. Click my subscription and notification bell. Okay, lagyan pa natin ng title. Paano yan? Lagyan ng title ito. Hindi ko alam paano maglagay ng channel dito eh. Community meditation, chat filter, the messages, all messages. Hello, good morning, good morning, good morning. Live chat on. Anyone? Message Lino. Okay, mag-comment po kayo dyan sa inyong kung ano ang inyong masasabi dito sa resulta ng ating pakikinggan ngayon. Okay? Thank you for watching.
9.5 billion to the program appropriations.
Ulitin natin. Let's start.
Originally was argued that there is an additional insertion of 449.5 billion appropriations, which originally was set at 281.9 billion. Clearly, there is a huge increase in that the total and program appropriations ballooned to 731.4 billion. The legislative intent of this prohibition, according to the constitutional provision, is to prevent enormous budgetary risks. How does the BICAMERAL Conference Committee account
Thank you for 28 watchers, viewers.
A clear contravention of this constitutional provision.
Hello everyone, I'm listening for the result of the bicameral and GAA insertion. This is our budget in the Philippines. It's all about our budget.
Your Honor, because that provision applies the prohibition to increase the budget submitted by the President does not refer to the NEP or the National Expenditure Program submitted by the President, but it refers to the budget of expenditure and Financing, or BESF, which is the budget document specified in Section 22 of Article 7 on the Executive Department as the basis for the General Appropriations Act. What I'm saying, Your Honor, is the purpose of that provision is, as you correctly stated, to prevent any budget deficit, any humongous or any very large budget deficit. That's why Congress has to look also at the funding or financing side, not only the expenditure side, like the net. Now, since the concept of unprogrammed appropriations is something like on standby, only when funds are available, only when there is an excess collection from revenue, only when new foreign loans are granted, then that is not counted for purposes of determining whether there might be a budget deficit. When the corresponding funding will come in, that's why it's unprogrammed appropriations, Your Honor.
Well, the Constitution says appropriations do not cover and program appropriations.
That is correct, Your Honor, but we have to understand the underlying reason for that particular provision. And as I explained earlier, we are referring to the BESF. The total amount of 5.7 trillion, Your Honor, was not changed in the GAA. It's still the same because we are only looking at the obligation side, referring to program appropriations and automatic appropriations. The inclusion of the unprogrammed appropriations is there only on standby, but it does not constitute the obligational, the list of obligations that the government will have to comply as for its operations.
Attorney Carmenares, if you have any refutation, it is on that in your memorandum. My time is I hope you are listening, since you are the one in your petition that made such allegation. You can expound your refutation as what the Solicitor General said. That concludes my interpretation. Thank you. Thank you, Chief.
I will ask additional questions, Your Honors. Thank you.
Paragraph 3 of Section 11 of Republic Act 11223, Universal Health Care Act, says that no portion of the reserve fund shall accrue to the national government, any of its agencies or instrumentalities, including government-owned or controlled corporation. How do you now reconcile this clear prohibition with the directive of the Department of Finance under the purported mandate of GAA 2024 to remit the money to the National Treasury?
Your Honor, the prohibition refers to any part of the reserve fund or income thereof or therefrom from being remitted back to the general fund of the National Treasury. Precisely, this is what Special Provision 1B and PhilHealth Circular 003 provided, which means that you make your own review of your reserve fund and the remainder, meaning outside of the reserve fund, is what will form the basis for the computation of any amount that is unrestricted and will be returned to the National Treasury. So very clearly, Your Honor, the reserve fund had already been set aside, and it's only the remainder from the computation of the unrestricted funds that may be the subject of a transfer or a return to the National Treasury. So there is no violation, Your Honor.
As early as in 1961, the Supreme Court, in the case of Henry, Archbishop of Manila versus Security, your number L-1.0045, January 20, 1961, held that funds contributed to the Social Security at that time Commission created by the Social Security law are not public funds,
Yes.
but funds belonging to the members or contributors held in trust by the government. Is that a ruling of the court applicable to this case?
No, Your Honor, that is not applicable because the sources of funding for the Universal Health Care Act do not come solely from the contributions by way of premiums of the members of PhilHealth. There are many other sources of funding for the Universal Health Care Act which do not come from, let's say, the paying members of PhilHealth. That is only a part of the funding sources for the Universal Health Care Act. By and large, the majority is from taxes.
Let's still into Article 6, Section 29, Paragraph 3. That's the Special Purpose Fund.
Yes.
That's the constitutional provisions which says all monies collected on a tax levy for a special purpose shall be treated as special fund and paid out for such purpose only. If the purpose for which such a special fund was created has been abandoned or fulfilled, the balance remaining shall be transferred to the general funds of the government. Do you know of a decided case wherein the Supreme Court with mention of this special fund?
Your Honor, I do not recall right now the title of that case, but I know a legal basis for making a distinction between what is known as soft earmark and hard earmark. There is a provision, Your Honor, in the administrative code, the revised administrative code, that, if I may refer to my note, Your Honor.
Yes, please.
渴望感受深度日本風情，除咗鳥取米子嘅沙丘、四國得到嘅漩渦，仲有日
Executive Order number 292, Book 6, Chapter 5, Section 44, heading Accrual of Income to an Appropriated Surplus of the General Fund. And it says, Your Honor, unless otherwise specifically provided by law, all income accruing to the departments, offices, and agencies by virtue of the provisions of existing laws, orders, and regulations shall be deposited in the National Treasury or in the duly authorized depository of the government and shall accrue to the unappropriated surplus.
Ayan, ito siguro yung ito siguro yung bill number na talagang binasihan nila kung bakit nilipat nila ang pera ng PhilHealth sa National Treasury. Hindi naman nabanggit ang PhilHealth dyan na ang PhilHealth funds should be transferred also sa National Treasury. Yan, dyan sila nagkamali. Kasi ang sinasabi lang naman dyan sa bill na yan is ang lahat ng fund ay pwedeng mailipat but except PhilHealth, wala namang nabanggit doon. Kasi nga, ang PhilHealth ay para sa health ng tao. Kaso lang, na talaga sila, they made a way talaga na lahat ng pera na nakukulikta ng gobyerno ay inilipat nila sa National Treasury. Paano na? Wala nang gagamitin ang tao pag sila ay nagkasakit. Anong kukunin nilang pera kapag wala ng pera, pag naubos na lahat? Di ba? It shouldn't be touched. Yun dapat ang nila, ang nasa isip nila dapat, ang panindigan nila na ang pera sa PhilHealth shouldn't be touched. Yung pera sa modernization ng AFP, hindi dapat yun tinanggal. Tapos yung pera naman sa education, dapat hindi nila yun kinuha. But the problem is they have touched it and they have transferred it into National Treasury, which is illegal. Kaya tuloy tayo. Yan kasi ang hirap sa administrasyon ngayon Lahat ng pera pinakialaman nila
Of the general fund of the government. In the following section, Your Honor, section 45, the heading is Special Trust Funds or funds other than the general fund only when authorized by law.
Oh,
And following
only
such rules
when
and
authorized by
regulations
law.
as may be issued by a permanent committee consisting of the Secretary of Finance as chairman and the Secretary of the Budget and the chairman, Commission on Audit, as members. So what I'm saying, Your Honor, essentially is if the law does not provide or create a special fund or a special trust fund, then any such income shall go to the general fund of the national government.
With all due respect, the Supreme Court in the case of Gaston versus Republic Lenders Bank, Judge number 77194, promulgated later on
Ito, judge, ito siya eh.
March 15, 1988.
Supreme Court judge.
The court had no occasion to initiate the doctrine of this, and this is what the court said. Revenues that levied for a special purpose shall be treated as special fund, which are administered for once the purpose has been the reason for the created has been abandoned, the balance in it shall be transferred to the general fund of the government. The question is, what funds to implement the universal health care system is the total increment of the sin tax collections. Can we not consider these funds that may be derived from the sin tax collections as funds considered held in trust by the PhilHealth?
Tama. Yes, right.
Your Honor,
Not all funds.
Let me refer to Section 37 of the Universal Healthcare Act.
salon 做 treatment 嘅效果，平前爆水珠珠烏木梅。
Your Honor, if I may, proceed. Referring to the very last paragraph, Your Honor, of Section 37 of the Universal Healthcare Act, may I quote, "The amount necessary to implement the provisions of this Act shall be included in the GAA and shall be appropriated under the DOH and national government subsidy to PhilHealth. In addition, the DOH, in coordination with PhilHealth, may request Congress to appropriate supplemental funding to meet targeted milestones of this Act." The implication, as far as I'm concerned, Your Honor, seems to be that all of the sources of funding, including those arising from the sin taxes, will have to go to the general fund and to be eventually appropriated by Congress under the DOH and national government subsidies to PhilHealth, presumably taking into account the amounts collected from the various sources, such as the sin taxes. That is my understanding, Your Honor, but it is not the same as this law creating or providing for the creation of a special trust fund like the Coco Levy Trust Fund, which is set apart from the general fund of the National Treasury. Here, the law itself very clearly states that the amounts necessary to implement the provisions of this Act shall be included in the GAA.
My final question deals with Article 6, Section 25, Paragraph 1. Under this constitutional provision, Congress may not increase the appropriations recommended by the President as specified in the budget. Petitioners in GAA number 7275405 argued the claim that there is an additional insertion of 449.5 forecasted at 281.9 billion. Clearly, there is a huge increase in that the total and program appropriations ballooned to 731.4 billion. The legislative intent of this prohibition, according to the constitutional commission, is to prevent enormous
Yes.
budgetary deficits.
Yes.
How does the bicameral conference committee account for such enormous increase? Is this not a clear contravention of this constitutional provision?
No, Your Honor. Because
No.
that provision applies the prohibition to increase the budget submitted by the President does not refer to the NEP or the National Expenditure Program submitted by the President, but it refers to the budget of expenditure and financing, or BESF, which is the budget document specified in Section 22 of Article 7 on the Executive Department as the basis for the General Appropriations Act. What I'm saying, Your Honor, is the purpose of that provision is, as you correctly stated, to prevent any budget deficit, any humongous or any very large budget deficit. That's why Congress has to look also at the funding or financing side, not only the expenditure side, like the NEP. Now, since the concept of unprogrammed appropriations is something like on standby, only when funds are available, only when there is an excess collection from revenue, only when new foreign loans are granted, then that is not counted for purposes of determining whether there might be a budget deficit, because it will only come to play when the corresponding funding will come in. That's why it's unprogrammed appropriations, Your Honor.
Well, the Constitution says appropriations do not cover that program and program appropriations.
Yan.
That is correct, Your Honor, but we have to understand the underlying
No.
reason for that particular
Couldn't be understand
provision.
it.
And as I explained earlier, we are referring
You need to respect the law.
The total amount of 5.7 trillion, Your Honor, was not changed in the GAA. It's still the same because we are only looking at the obligation side, referring to program appropriations and automatic appropriations. The inclusion of the unprogrammed appropriations is there, only on standby. But it does not constitute the obligational, the list of obligations that the government will have to comply as for its operations. Attorney Carminares, if you have any refutation, it is on that in your memorandum. My time is, I hope you are listening, since you are the one in your petition that made such allegation, you can expound your refutation as what the Solicitor General said.
Ayan. Kasi, wala nang lusot dyan ang mga taga-Congress. Kahit ipilit nyo pa yan, yung Article 37 na yan. Kasi, nakalagay talaga sa isang article dyan na hindi pwedeng galawin at hindi pwedeng insertan ng any funds ang GAA. Kaya, kung ako sa inyo, magtago na talaga kayo. Wala na kayong magagawa. Korte na yan. Hindi bobo ang mga korte kung hindi nila kakampihan ang mga taong bayan. So, good luck everyone. This is your Kabyut Vlog. Please don't forget to subscribe and click my notification bell para lagi kayong updated. Bye-bye. Good morning. Happy Wednesday.